Next session is the second Masterclass of the day, how to keep the SEC from suing your client. That'd be good information to know. So let me start with our moderator, John Barry. John's a partner at Munger and a seasoned litigator. He's litigated dozens of cases to summary judgment, argued more than 40 dispositive motions and appeals in federal and state court and appellate courts. John was previously an associate regional director in the SEC's LA office, where he co-led that office's enforcement staff, and also previously a regional trial counsel for that office. Welcome, John. Thanks. Gary Leung is assistant regional director in the SEC's LA regional office. He's been with the SEC since 2012 and was promoted to assistant regional director in 2020. Welcome, Gary.
Thanks, Bruce.
Brad Mroski is partner and managing director at AlixPartners. He has over 20 years of experience in forensic accounting, auditing, consulting, and litigation services, and served for 6 years as assistant chief accountant in the SEC's enforcement division. Brad, great to have you with us.
Thanks, Bruce.
Walker Newell is assistant general counsel for litigation and regulatory enforcement at Robinhood. Robinhood Markets specifically, previously served for 5 years in the SEC's Division of Enforcement in the San Francisco regional office. Welcome, Walker.
Thanks, Bruce.
And finally, Jessica Valenzuela is with us today. She's a partner in the Palo Alto office of Gibson, Dunn, and a member of the Securities Litigation Practice Group. Her practice focuses on securities, corporate governance, and other complex business litigation, including the defense of securities class actions, derivative suits, and M&A related class actions. Welcome, Jessica.
Thanks, Bruce.
All right, turn it over to you, John.
Thanks, Bruce. So our topic for today is how to keep the SEC from suing your client. And we thought I could stand up if I had a microphone and just say, settle, drop the mic and walk off stage. And then we all could go to happy hour and be done with it. But I think Bruce would be upset with us if we did that. So we're going to have a pretty good in-depth discussion about this. And I think you've heard it probably a dozen times today about the seaboard factors. But we thought we'd focus on one of the seaboard factors in discussing a critical part of keeping the SEC from suing your client, which is self-policing. It's one of the 4 factors that I think it's overlooked in the assessment of how to get cooperation credit in trying to keep the SEC from suing your client. And it's one the SEC has recently, I think, focused its attention on. And so I think to start the conversation, we'll turn to our sort of in-house resident perspective with Walker, and just Walker, from a client's perspective, what is a good way to think about self-policing and compliance?
Yeah, thanks, John. I think that when you look at, when I think about how I thought about compliance as outside counsel, I didn't think about it much. I didn't really have a lot of chops in that space as sort of just a straight securities enforcement lawyer. But I've seen folks who do sort of sit in both roles, where they know the investigations, they know what happens when a crisis emerges. They also know about compliance program design. They know how to handle an ICC if an ICC is imposed. They know how to think about what your organization looks like really carefully, think about who's in what seat, think about what kinds of proficiencies and skill sets you actually need. I think that's a differentiator for outside counsel. I think a lot of outside counsel and a lot of firms don't necessarily have that function built out, and I think it's something that in my seat, when you see it, you know it, and when you don't see it, you see kind of how it makes a difference. Just to kind of give you an example, like let's say, and this is sort of a little bit adjacent, but I think it's of a piece with the same theme. Let's say you've identified an issue internally and you're in the process of trying to self-police it, and whatever posture, and maybe there's an active investigation, maybe there's not. You look to outside counsel, they're advising you on what to do vis-a-vis the regulators, obviously, and they're talking to you about whether you should self-report, and they're talking to you about, what the investigation is going to look like. But are they in the mix with you in the business, figuring out how to fix it and figuring out what is actually happening? Not just looking to the business and saying, okay, guys, what's the timeline for remediation? Are you going to be done in 2 months? Are you going to be in 3 months? I hear that, that's something that I've heard over the course of my career at just surface level enforcement lawyer, like, just let us know when you have it fixed so that we can report that to the government. Then you see folks who actually try to get in the weeds and actually understand what the business is doing, issue spot other tangential issues that may be emerging from the issue that you've identified and are beginning to self-police, I think it really differentiates outside counsel who can do that, and I don't think it's all that common of a feature. So I think self-policing, like finding something, reporting it to the government if appropriate is one thing. When you have counsel who can really be your partner throughout that process, that is something extra.
And I think it's an important thing to think about also, because I think that's really helpful to think about, Walker. Another part of it is, when you're the self-policing component to trying to get cooperation credit, it can be a huge selling point for the SEC if the company or the firm had its own procedures in place that in theory should have stopped whatever happened and for whatever reason didn't. But if you're able to show the SEC that you had something in place before it all began, that can be huge and can overcome maybe other deficiencies in the seaboard factors. So Gary, SEC, we've just heard Walker's client perspective. What's the SEC's perspective about that one factor, self-policing?
Well, John, I think that's absolutely right. Self-policing is obviously one of the seaboard factors. It's something that maybe goes less noticed than the others. We think cooperation, we think a quick self-report, we think remediation, but self-policing is on equal footing with the other three. And I think in the 2 years that we've had our current enforcement director, he has spoken at venues like this quite frequently about the concept of proactive compliance. The goal of proactive compliance, the measure of proactive compliance, and it means precisely what the words mean. It means sort of educating yourself about the law and relevant external developments, and that's in particular with respect to emerging risk areas. So, we're trying our best every time you see a settled order to message what the conduct was and how and why it violated the federal securities laws. Proactive compliance also means proactive engagement and monitoring internally within your organization. And last but not least, you can have the best policies and procedures in the world. That's only half the battle. I mean, you got to execute on those. You got to implement them. You got to do it. So just wanted to amplify that concept of proactive compliance. And I think the proof is in the pudding. If you look at that Kronos order that a lot of folks have discussed, during the 5 or 6 or 7 times that panels up here have talked about cooperation, there's a paragraph 38, and it's got an A, it's got a B, it's got a C, it's got a D. Those are 4 letters. There are 4 seaboard factors. The very first letter is A, and it refers to everything that Kronos did with respect to self-policing. And I think the main point is they had policies and procedures in place that caught the accounting error. They escalated it to the audit committee, and they took appropriate action.
I would just piggyback on that and say, most of my contact with auditors for the first part of my career was accusing them of doing bad things. But I, currently work with an incredibly strong internal audit team, and I can't overstate how important that is to the project that Gary is describing. I mean, I don't want to negotiate against myself, but I think auditors may be better than lawyers at really getting to the bottom of what's happening in complex business systems, really in particular on the tech side. I think lawyers sometimes don't get all the way there, but auditors, in my experience, do if they're really good. And I think that understanding, that deep understanding, really serves the project of trying to root out issues yourself as an issuer or a registrant.
Yeah, I think that's an important point, Walker. I think that the cases I've had where we've been able to get cooperation credit pushing the self-policing point, there was always a strong internal audit function at the company when that's happened.
I want to jump in I want to pause and let Gary retroactively make his disclaimer. Having been at the SEC, I know how important that is. So.
Evidently, there weren't adequate policies and procedures in place to ensure my compliance with the disclaimer requirement. I should let you all know that the views that I just expressed, as well as the views that I will express, are my own and don't necessarily reflect those of the commission, its commissioners, our chair, or my colleagues on the staff.
Internal audit.
Now that that's out there, I actually want, and maybe it's an unfair question for you, but I want to put you on the spot a little bit. I was inspired by Gina earlier. So when we're talking about the Kronos order and the cooperation and the seaboard factors, one of the things that it's interesting to me, if I remember correctly, an ICC was imposed. And so there was undertakings. And how does that square with this idea of remediation, which is a seaboard factor? And, policies and procedures and adherence.
In other words, if the remediation was good enough to satisfy Seaboard, why is an ICC required?
I can see at a conceptual level why there might be sort of a tension between good remediation as well as an undertaking along the lines of an ICC. But to that, I'd respond, the imposition of an ICC, is this going to advance our overall goal of investor protection? Probably. Is it going to message to industry that in the event of a securities fraud violation like the one at issue in Kronos, where you have a fairly significant accounting fraud, there will be consequences? I think it messages that. So in that case, the staff felt it appropriate to, notwithstanding the significant remediation by the respondent, also seek an undertaking along the lines of an ICC.
What I think is interesting about the Kronos case, and Gary, your alphabet was correct, it does go A, B, C, and D. It's got the 4 factors, but what I think people struggle with is that, and we've heard it, I don't have to beat this dead horse, but defense counsel will struggle with the fact that almost every company can do what those 4 factors in the Kronos case say. Most companies do have some kind of internal policies to try to combat fraud. Most companies, when trying to get cooperation credit, have self-reported. Most companies have gone through some process and maybe fired somebody or done some kind of censure internally, so they've remediated. And they've, in their mind, cooperated with the SEC staff during the investigation. So what I struggle with is the fact that those 4 factors, A, B, C, and D, in paragraph 38 of the Kronos order, 9 out of 10 companies feel like they could satisfy them, but don't necessarily get the same 0 penalty that Kronos got.
It's a matter of degree, right? I mean, I think reasonable minds can differ on the quality of the cooperation. You can check off all the boxes, but in some cases, the cooperation is going to be so substantial. I mean, you can credibly argue that the staff would not have gotten to this place without us providing this information in this manner, nor would they have gotten to this place as quickly. And I think, again, it's a matter of degree.
And I happen to agree with that. I remember being at the staff and now being on the defense side, telling the clients the same thing I told people who are defense counsel who are facing me. Just responding to subpoenas isn't cooperation. And sometimes clients don't like hearing that, but you've got to do more than that, I think is what you're saying.
Yes.
Great answer.
So from the defense lawyer perspective on the panel, and we were talking about this a little bit in preparation for this, Gary, there's a tension between zealous advocacy on behalf of your client, which as a defense lawyer, I have an ethical obligation to zealously advocate for my client, and the concept of cooperation, right? There's an inherent tension in that. What's the SEC's perspective on the view of defense counsel who are advocating for their client's interests, but also have an interest in cooperating with an investigation?
I think zealous advocacy is important. I don't take it the wrong way at all. I think first principles when we're thinking about cooperation, and this is a two-way street, right? One, it's sort of an open flow and complete flow of information. And 2, it's just sort of approaching this interaction from both sides in a credible way. So, zealous advocacy can mean a lot of different things, but I think about it in terms of a continuum, right? Sometimes you're just framing the record, but you provided the whole record. Well, that's just framing. Sometimes you're, shaping the record around the margins a little bit, and you're sort of suggesting that maybe these facts don't mean what you think they mean. Okay, that seems sort of zealous advocacy. But other times you might be in a position where you're so far down the continuum that you're really carving out parts of the record and not passing it along. And I think that flips a switch with me and makes me sort of think twice about whether this is zealous advocacy or this is advocacy that's problematic.
It sounds to me like you're saying that from a defense lawyer perspective, we should always maintain credibility with the staff across the board, whatever that might mean under the particular facts or circumstances of a matter.
Absolutely, and we should with you.
So one thing, we've been talking about cooperation a lot. It's been discussed a lot throughout the day. One thing that hasn't been discussed a lot, Gary, is how to get cooperation credit for individuals. So could you touch on that a little bit?
Of course. So the policy statement by the Commission on cooperation for individuals cannot drink, but it is in the 7th grade. So 2010 policy statement, again, 4 factors. What was the assistance provided? What was the importance of the underlying matter in which the individual was cooperating? What is the Commission's interest in holding that cooperating individual accountable? And finally, the profile of the individual. So, those things mean what they say they mean. Yeah, how good was the assistance? How substantial was it? Did it really move the needle in terms of helping the staff arrive to the recommendation that they made and helping the staff get there much more efficiently than they otherwise would? Importance of the underlying matter, we're going to think about the case in which the cooperation arose from. I mean, was there substantial investor harm here? Is there an interest in holding this individual accountable, notwithstanding the cooperation? So that goes to the culpability of the conduct, the severity of the misconduct, and whether or not the individual took it upon themselves to remediate. And then finally, the profile of an individual. I mean, I think this is no surprise, but if we have a cooperator that is a recidivist who is not accepting responsibility for what they did, they're probably a poor candidate for cooperation. So a couple cooperation tools that we apply in individual cases. The main one's the cooperation agreement. We've got a standard form agreement. And, at a high level, the enforcement staff is going to agree to make a recommendation to our client that takes into account and gives some credit for the cooperation that we've received. That commitment is conditional. We want to see the cooperator agree to provide substantial assistance, follow through on that substantial assistance, whether it's for an ongoing investigation or related enforcement litigation in federal court. In many cases, the cooperator is going to have to agree to waive the statute of limitations with respect to any potential violations alleged against them. And then last, the cooperator needs to hold up their end of the bargain. So that's our standard form agreement. We've done a few of these in a couple recent examples. We had a litigated administrative proceeding in which remedies was bifurcated. Ultimately, and this is an order that came down in March of this year, in the matter of Mark Allen Bourgeois, the commission determined that no civil monetary penalty would be imposed in light of the respondent's full cooperation in ongoing district court litigation with respect to other individuals and entities involved in the fraud. Same sort of outcome in another case from 2020 in the matter of Baden. Monetary relief, claims for monetary relief were completely discharged based on the fulfillment of the respondent's cooperation obligations, again, during the division's ongoing investigation as well as related litigation in court. So that's one of our tools. Another tool is a deferred pros agreement, and we've done those. The LA office did a deferred pros agreement with a tipper in an insider trading case a few years back. And there, same sort of commitment from the cooperator, a long-term tolling agreement. There will be undertakings in a non-pros, and those undertakings are probably going to involve the payments of monetary relief. But for the Division of Enforcement's part, we are agreeing to forego an enforcement action upon satisfaction of the cooperator's obligations under the non-pros.
And what I find difficult about individual cooperation credit versus corporate cooperation credit, when you represent a company, there's an expectation that eventually you're typically aiming to settle the case. You know the SEC's there. You probably self-reported. With an individual, you can't get much assurance, right? I mean, the company sort of expects, okay, we can't get much assurance where this is going to be, but we're trying to do our best to cooperate to get the right outcome. With an individual, right? The SEC can't give you much assurance when you're making the decision whether or not to cooperate or not. They can't give you much assurance. It's like, is this going to end up actually working? And am I actually going to get credit, or are they actually going to end up charging me? And so you're making that decision a little bit blind for an individual.
You know, I have two reactions to that. The first one is if we're talking about what kind of benefit can I be assured of with respect to monetary relief? You know, sort of core principle, I mean, disgorgement does not come off the table, right? Because you disgorge in full your ill-gotten gains, you're basically in the position that you were before.
Did you talk to Michelle Lane before making that comment?
We did not have an express conversation, but I understood that to be her view, and it happens to be mine as well.
Okay.
And then, you know, my second reaction is there's a reason for that. We need to assure ourselves that the cooperation is going to be what it was represented to be and that it comes through. And I think sort of the best example of why we structure it in this way was, you know, we had an insider trading case. I think it was with Rakoff. It was tried by our Philadelphia office. And there were two levels. There was I think we went first level tippies all the way down to insider. And one of those defendants, signed up to the cooperation program. At trial, he did not cooperate. I don't know the specifics, but he did not hold up his end of the bargain. And while the commission did prevail and obtain a jury verdict at trial, that was certainly impactful of our odds and how we were able to successfully litigate the case. So I think the cooperation agreement got yanked. When we moved for monetary relief, we asked for a lot more than we otherwise would have, and Judge Rakoff gave it to us. So there's a reason for that, and that's the best response I can give you.
Okay. Well, let's move on. Gary's been talking a lot, so let's go to the defense side of it. And so the SEC is now investigating. We've done the self-report. Somehow they found out. We're still hoping to avoid getting sued. They're into testimony now. What do the rest of the panel think about? What the things to do, things not to do when your clients or your clients' employees are testifying in front of the SEC? Jessica?
So if I represent the company, I think, number one, I want my employees, my executives, to have competent separate counsel so that their interests are represented. And hopefully it's somebody who I know and can work well with, and we can have a coordinated defense that's going to inure to the benefit of the company as well. In terms of how to conduct oneself at testimony, I do treat it differently than I would in a non-enforcement civil litigation. I won't object as much or speak as much during the testimony. That's not to say that I might not lodge an objection here or there or make a comment to try to clarify the record. But I think for the most part, I'm not going to be as active a participant as I normally would be. It's a different type of process.
Do you ask questions? And when do you ask questions?
Typically, no. Certainly not at the conclusion of the testimony. I might lob a clarifying question in the middle. Sorry, SEC enforcement staff out there. But I think if there's a question that really isn't clear or misses sort of a concept that might make the answer unclear, I might clear up the record on the spot. For the most part, I haven't had staff take issue with that because I use that very sparingly and really only when there's a acute need for it.
Can I make a pitch for something from the in-house side? Like, this is extraordinarily basic. Know the facts. I can't overemphasize that enough, and I think that you can see it very clearly from this side of the table. Outside counsel are busy. There's business demands. There's lots of reasons why you're busy. You're juggling. But if the folks who know the facts aren't actually the ones handling the testimony, then they sure as heck need to have transmitted that effectively to the folks who are. And often it's better if the folks who are handling the testimony really do have that grasp. And I think I can think of a number of occasions in my career that where that has not been true, and I think it's impactful. The record comes out differently.
Yeah, and I'll jump on that a little bit. I mean, where we typically get involved in my capacity on testimony is on the prep side. And the facts thing is key, especially in accounting and financial reporting cases where it's oftentimes dealing with a complex set of facts, oftentimes 3, 4, maybe more years ago, and sometimes with an employee who's no longer an employee of the company, and refreshing their recollection on specific transactions, how things were done, because these guys just don't have the memory, and getting them ready and tight on those things.
And to jump on a little bit more about the testimony, one thing I think is interesting, and I think it's easy to lose sight of it, because these aren't depositions. People don't treat them like depositions. They're SEC testimony where the staff attorney is asking all the questions. Rarely do you ask any questions. But it is evidence, right? And it can be admitted at trial. And if there are questions there that there's a compound question, for example, you know, there may be times when you do need to actually do a formal objection or at least correct that. I don't know, Gary, how you feel watching defense counsel objecting in SEC testimony.
I think everybody in the room has a shared interest, and that's to get the complete, accurate, and best testimony that we can get from the witness, right? So there's that. I don't know. I mean, I think SEC attorneys have done so much testimony that, I mean, they know coaching when they see it, right? So at a certain point, you're going to sort of get over that line from, well, I think there's been a misunderstanding here. My witness is under oath. They take that very seriously. They want to make sure that transcript is right, to something closer to, I'd rather them not say that. And I think they don't have a perfect recollection. I don't think they have a complete specific recollection. So maybe when I spend 7 hours prepping that witness, I'm going to sort of emphasize to them, maybe you shouldn't speculate. And then, you know, we go to the testimony room and we get objection calls for speculation 5, 6, 7 times in an hour. And invariably the response from the witness after hearing that objection is, I just can't remember and I really don't want to speculate. And that to me is problematic.
Right, right. Well, we've gone through some of the do's, what things to do in the testimony. How about some of the don'ts? Jessica, what not to do as defense counsel in testimony from your perspective?
Let my client say anything under oath that's not true. Pretty obvious one, I suppose. I think it's, you know, some of the rules that apply to normal depositions. It's don't let your client go too long without a break, because then it gets harder to have a clean record, I think, for both sides. I said it earlier, I don't want to be too obstructionist and interfere with the SEC staff so they think we're not cooperating, because, you know, if it's voluntary testimony, obviously that's probably better from the staff's perspective, but I don't want to seem like I'm trying to interfere or impede the staff's ability to get the facts. And, you know, to dovetail on a point that, you know, Walker made and that Brad made, you know, be prepared and know the record going in.
I mean, one thing my practice has been is I don't really formally object. I tend to just say, maybe there's you know, I think maybe what you meant by that question, or maybe you're trying to get at this question, and that tends to go okay. Because I remember when I was at the staff, I remember seeing a defense counsel come in and they treated it like a deposition and very aggressively objected, even beyond what's allowed in a civil deposition. I mean, every fifth question was objected to. And what that not only does, it doesn't really create a great record, but all it really does is upset the SEC staff. And they were upset after that.
Yeah.
So
I agree with that. I think maintaining a collegial relationship with the staff is really important, and maintaining credibility is important. And I think if you were to come across too aggressive in testimony, you run the risk of damaging that relationship irreparably, and that's not going to be in the best interest of your client.
right. So moving on, another big topic of when an investigation is happening, what to do to try to avoid being sued, are attorney proffers. and I don't know who wants to jump in first on this topic. It's a difficult topic of when do you offer it? Are they effective? I can ask Gary that, but let's start with when Brad, Jessica, Walker, your views on when do you try to get an attorney proffer done rather than give
You want to start, Jessica? I mean, I don't think of it in terms of a proffer. I think of like presentations to the staff. So if we're calling that a proffer, I mean, it's, I've found it generally a good thing. The more that you're getting an opportunity to present information to the staff, more often than not, we're in a position in our roles as both defense counsel and advisors to defense counsel. We have access to more information than the SEC does, generally speaking. And if we think that there's information that can be helpful to the SEC in their fact-finding mission, and we were talking about this a little bit before, that oftentimes I've found success by helping answer questions that the SEC is not asking, because we know it's pertinent and relevant to what they're investigating, but their view is narrow, and we have a wider view because of the information we have access to. And so finding a respectful way to convey that information that's relevant to what they're investigating, in my experience, has gone a long way in not only getting cases closed, but if not closed, resolved more quickly.
Mm-hmm. I'm also pro-presentation. I think there's a distinction between like a more bland, vanilla, hey, here are some facts that we really think it would be helpful for you to know, and we're going to get those right out in front of you as soon as we can so you can consider them, and a different flavor of like, you know, we understand why you started this thing, but this really doesn't make sense, and we really think it should go away. And I think the latter, you see different approaches amongst defense counsel, and you know, how big of a risk appetite they have, how much do they think that's going to ruffle the staff's feathers, and how much of that, you know, when are they going to take the client's lead there? And I had a case in private practice where I think we had sort of an impetus to do that based on the business environment the client was facing, and we did it, and we went into the staff very aggressively and talked about why we understood, you know, respectfully, but this was not something that was going to result in enforcement action. I think it got the case closed more quickly than it would have otherwise, but it's context specific, and I don't think it's the strategy in each instance. But I've seen folks be very conservative in that space, and I don't think it's always the case that you should be that conservative.
And I think there are a couple different points where you might want to go in and ask the staff if you can make a presentation. One instance in particular is where maybe the client is in a novel industry that the staff attorneys might not have come across, and there's some important context that would be important in as the staff goes through the massive document production and sort of understands what was happening at the company real time. You want to provide some context around you know, what the environment was that those business decisions were being made in. Or if it's a presentation where you're really trying to get the staff to think about a potential settlement on you know, negligence terms as opposed to under 10B. That might happen later in the process after more of the documents have been produced and we know what's out there and what the story looks like from an evidentiary perspective. So there are a lot of different opportunities like during the investigation process where it might make sense. And I usually want to go in and talk to the SEC as often as they'll want to hear me, because I think it's important to convey my client's narrative and sort of orient the facts in a way that I think is supported by the evidence and that is the most helpful framework from a defense perspective.
What I find difficult sometimes in making the assessment of when to go to the SEC is sometimes the SEC's investigation is incredibly broad. And there may be 24 issues they're examining, and you don't really know which ones they actually truly care about and which ones they may just, they spot it as an issue, they've asked for records, but it's a much lower priority for them. And I think that's sometimes the difficult assessment of, do I go in and present and I'm not quite sure yet which issue they really care about, because I might be presenting on issue number 12 that they're probably going to drop and not hitting issue 1 because I went in too early.
I've done that before, where I've gone in and presented on one issue and it turned out that the staff was interested in something completely different. But there's even value in that because I learned information I didn't know before. And then from my perspective, we were able to sort of orient the SEC towards the evidence that was relevant to that issue. And it ultimately ended up in a complete declination. But I do think, John, that meeting had value because I came away learning information I didn't know going into it.
Right.
I've taken the Jerry Maguire approach on that, help me, help you kind of thing, when having the conversation with the staff. A lot of it goes to who you're dealing with on the staff, the rapport you have with that person, the relationship. But, if you've got 12 things you care about, help us prioritize what's of highest importance to you so that we can focus our energy and efforts there. More often than not, I've found that they're receptive to having that dialogue. Sometimes they want to keep things close to the vest, and that's fine. But I think the dialogue is helpful. And a lot of times, in terms of narrowing and getting them to narrow their request, maybe it's not issue specific, but it's just, if I think of when I was on the staff and I would send a request for documents, a lot of the times it was unnecessarily broad because I just didn't understand the nuances of the company and their systems and their processes and the way things worked. And so sometimes you can use that as an opportunity to educate them and say, well, this is how it works. And so can we talk about your request for 3 years worth of all general ledger data and maybe narrow it down to here?
Did you just admit that as an SEC staff member that you had unnecessarily broad document requests?
No, everybody else did. Absolutely, I did.
I was guilty of that too, so for what it's worth.
So one thing we talked about when we were planning for this panel was talking about, do you submit expert reports to the SEC either during presentations or as part of your presentations or during the Wells process? Thoughts on that?
I've done numerous expert reports for Wells submissions, and had a very high degree of success, quite frankly, in terms of whether it's for an individual or a registrant. A lot of the times when the SEC Wells is, and I'll get your perspective on this, Gary, because I'm really interested, they will cast a wide net. And they'll be satisfied with not all the fish in that net coming through to the boat. And so sometimes you'll get that client that's, they're on the line with, and you'll do a Wells submission, you'll do an expert report with that Wells submission. It'll be persuasive, and the SEC is still going to get its pound of flesh elsewhere. And so I've had a lot of instances where clients have been not ultimately charged after being Wellsed.
Gary, your thoughts on receiving an expert report? Helpful, not helpful? Depends.
It will depend on the facts and circumstances, but as a general matter, and this is a personal observation of my own, I like more information rather than less. If there's a technical issue that there's a counter argument for that we haven't fully gotten our arms around, I want to know what that expert opinion testimony would be if we were to litigate this. It's good for me to know. So by all means, more is better than less.
Brad, you've said you've done them. What kind of examples of expert reports have you put in? What issues?
In internal controls. So there was a case where there was executive perquisites, undisclosed perks. And one of the individuals was responsible for approving the expenses of one of the executives that wasn't being disclosed. And so that individual was Wellsed, and we did an expert report around the ICFR components of the company and what this person's role in that process was. And he ended up ultimately not getting charged. So that was one example. We had another recent one that was a disclosure case alleging that certain material disclosures weren't made regarding trends in the business. And we put economic analysis together. We actually went in, we presented, did an expert report for that. That individual ended up not getting charged. So rarely, or I should say it's more on those types of issues than a true misunderstanding about the application of GAAP, say.
Right.
Because at that point you have OCA weighing in, you have a lot of different people weighing in, but it's more these things on the fringes.
Right, makes sense. We've been talking about presentations and how to do them and what not to do. One question often gets asked is, should clients attend presentations with the SEC? And Walker, if you want to start with that, what do you think about clients attending Wells presentations, pre-Wells, post-Wells? At any point, when do you think it's appropriate, not appropriate?
If you're talking about me, the answer is always yes. But more broadly, I think, like if we're talking about client as in-house counsel, I'd be interested in the panel's views. I don't see why not. I see no reason why not. I think often, obviously this is, I'm a little bit biased here, but I think in-house counsel has perspective on the business that outside counsel, even the best, often don't. And I think that I've seen instances from my time on the staff when in-house counsel was in the room and was able to add something meaningful and accretive to the discussion at an important time that otherwise would have had to been taken away and discussed in a week, and that can be spiky and slow things down or make the dialogue less productive. Also, I don't know. I don't think it's really much of a signaling thing in either direction. If it's an important meeting, you're representing an issuer. Why wouldn't the client want to be in the room? But I suppose if it's someone from the business and not from legal who is trying to sit in, I think that's a dicier proposition, one you're going to want to think very hard about.
So I think it really depends. I've done it both ways. Sometimes I've had instances where the in-house counsel is also the chief compliance officer, and that was an individual that the SEC was looking at as, potentially falling asleep at the switch with the gatekeeping function. And so I didn't think it would be appropriate under those circumstances to have that person attend. If I'm making a presentation on something like self-policing or internal controls or remediation, I often will ask the chair of the audit committee or the chairman of the board to attend to convey to the SEC that this really does have the attention of the highest levels of leadership. And I think it also gives the SEC an opportunity to ask questions, which I have allowed on occasion in an informal presentation. If other folks at the C-suite are sort of potentially targets, I probably would not include them. So I really do think it depends, but I have done it frequently, and I do think it does convey sort of the level of attention and importance that this process has at the company.
Yeah, I think generally speaking, if they're quote-unquote targets, even though the SEC doesn't use that word, you probably don't want them in the room at all. But I found it effective. I remember being on the SEC side, and I've done it since coming out, of having like a high-level officer, not in-house counsel necessarily, but a high-level officer there, even if they don't say anything, I think has been effective in persuading the SEC that this company does care about what's going on, is trying to do the right thing.
It was always impactful to me when I was on the staff. If the company, if the client, if management showed up. And it varied based on where you were at, right? There were certain early stage investigations where they wanted to come in and show us there's nothing there. And there was instances I can recall where they were successful, but they would bring their C-suite and their, all the relevant people. There was cases that were in the resolution phase, and the general counsel would fly halfway across the world to have a meeting with us. And I viewed it as them caring enough to be engaged in the process. I think Jessica makes a good point. If it's on remediation, if you're gonna, fall on the sword, but you're trying to minimize the damage a little bit, and so we're going to talk about remediation. I've worked with clients to say, hey, CFO, you're going to be doing the talking here, because they got to hear it from you, not me, not counsel. You have to own this remediation.
Yep.
I think there's always the discussion of whether you're opening one of the senior execs up to a firing squad, and I think that I've never really seen that in my career. I don't know if anyone else has, and I think it's kind of one that, if it's a context like Jessica was describing where someone is actually in the crosshairs, that's a big no-no. But if it's someone who is speaking for the business factually and speaking about why the business is trying to get it right and all the good things that we've done, and why either the staff should be nice in the context of resolution or not go forward at all, I think it's usually effective, and I don't see a ton of downside. I will say also though that on just bringing the in-house counsel into the room, I think defense counsel are sometimes a little resistant to that, and I think it's mainly because there's someone looking over your shoulder and someone really keeping you honest, and just a pitch for that. I think it's helpful. I think it produces better work.
I agree. I think we have like 3 minutes left. We haven't touched one issue that We have
1
1
minute.
minute left.
I'm looking at Bruce.
Bruce is
Bruce says
getting
1
antsy.
minute.
Bruce
We
is
haven't
getting
touched, and I'll just summarize it then. We haven't touched one issue that I think is very complicated in trying to persuade the SEC not to sue your client, and that's privilege issues and advice of counsel defense. I think, and Jessica and I were talking about this before, there are a lot of issues. This could take more than 1 minute, 45 seconds that we had, but one issue that I think is incredibly complicated is if you represent an individual, a former or current employee of a company, and the company's not waiving. That can be very complicated. Your client may have a rock-solid advice of counsel defense, but as long as that company doesn't waive it, you're going to have some problems. You may be able to successfully litigate that in district court, but in front of the SEC, and you can't. The company, for example, is here he comes. The company's dealing with a class action, for example. It's a difficult thing. They're not going to want to waive, and you, as representing the individual, put in a very difficult spot. There, I'll stop.
On that note.
Thank you, John. All right, terrific. Thank you, guys.